Hey, good evening, everybody. Thank you so much for everyone being here today. I am so grateful for the opportunity to come in front of all of you on this wonderful Father's Day. But I also want to just wish a happy Father's Day to all of our fathers out there. Thank you so much for everything you do. Fathers are so much needed and so much appreciated. And what better way to spend a moment of your Father's Day, whether you are a father or just a parent or you're a child, wherever you fall, what better way to spend a few minutes on your Sunday than to talk about estate planning? Because all of us we know for without a shadow of a doubt that we all gonna leave this earth one day. And a lot of us don't really put a lot of thought into how do we want to leave things when we go. And of course, there's always going to be a lot that is outside of our control, but there are so many things that are within our control that I want to talk to you all today about estate planning, the importance of it. We're going to get into what is it. And we're also going to talk about heirs property. A lot of people join my channel, they join my webinars. They're a part of the community that I have helped to create because they are interested in learning about heirs property. So we're going to talk about all of those things in some form today. For those who don't know me, I am attorney Veronica McClendon. I'm the owner and CEO of McClendon Law and Consulting. Our law firm works with people all over the state of Georgia to help them to create an estate plan or a legacy plan so that if they become incapacitated, they become ill, they're no longer able to handle their own affairs, or at the time of their death, they have a plan in place to make sure that the people that are important to them get the assets that they want them to have. So that's one thing that we do. We also work with families who own heirs property, who have inherited land or inherited a house and it's been in the family for a long time. And they're trying to figure out how do we now make some good use of this property that we have? How do we make sure that what we've built up over the years actually is a benefit to our family, to us as we go on into the future? So that's a big part of what we do. We also help families who maybe someone owned some property when they died. That property went to their estate, and now we're trying to help them to transfer those assets to their loved ones, whether they had a will or whether they did not have a will. We can help with that process. And then finally, we help people who are farmers and landowners to set up a strong business structure to own and manage their land, to own and manage their farm operations so that they're operating at the highest level that they can, making sure that they are treating their land, treating their farm business as an asset and not just a hobby or something that they're just doing, but it's something that actually has value. And I'm gonna just go ahead and give a shout out to Thaddeus Dawson on here. He leads up 10,000 Black appraisers, and they had a really great session this weekend where they talked about the importance of appraisers and people who help you to determine the value of all your stuff, all kinds of stuff. Everything you own has a value, and there are people whose profession it is to help you to determine the value of your assets. And I was reminded of how important my job is to help my clients to create a structure for the management of their assets so that they can maximize the value of it, so that they can retain the value and make sure that it continues to grow in value over time rather than diminish in value over time. This webinar is going to be a little bit on the a little more informal than some of the ones I've had before. I decided to give it a go without slides because I just wanted to see what would happen if we all come here with specific intentions and we do our best to help each other to come away with their intention fulfilled at the end of this webinar. So that is my goal here tonight. Others, y'all may have your own goals. So if you have any goals for how you would want what you want to come away with at the end of this webinar, let me know and I'll do my best to cover it as part of this conversation. So anything else anybody else wants me to cover tonight before I just go into some of the things that were on my mind? And we can, as you think of things, then put them in the comments, put them in the chat, and I will cover them as we go. But what I wanted to focus on specifically is What happens to your property after you die? And the reason why I wanted to approach it from this angle is because I think a lot of times when people hear estate planning, they think something really complicated. Some people say, I don't have an estate. I'm not really wealthy. I just have a few things here and there. And they want to make sure that their property gets to the right people. So I wanted to take it out of that whole estate planning framework or saying the words estate planning and just talk about what actually happens to our property after we die. Reason why I wanted to focus on this is because there's a lot of misconceptions about what actually happens to your property after you die. Some people think that if you die and you own property, just a minute. They think that if they die and they own property, a lot of people think that it just goes to the state. Like especially if they have real estate that has a mortgage on it, people think I don't own my house. I don't own my land because there's still a mortgage on it. And that could not be farther from the truth. At least here in the state of Georgia. Now, I will say some states they may treat real estate a little differently. So I can't speak broadly across the whole United States and definitely not across the whole world. But here in the state of Georgia, when you purchase real estate, whether it's a house or land, it's commercial property, an apartment building, whatever it is that you're purchasing, a lot of times people don't have the cash on hand to buy it outright. So they will go to a lender, they're going to borrow money, and they're going to get a mortgage on that property. And they're paying the mortgage off on the property. That doesn't mean that the bank owns your property. You own the real estate. If you went and you purchased this real estate, you own the real estate. And the bank or the lender owns a security interest in your real estate. So that means you own the title to the property. You are the owner. If anybody was to try to see who is the owner of your property, it is going to be you, the person who purchased it. The bank has a security interest in your property. That means that if you don't pay them like you said you were going to pay them under the contract, which is the mortgage contract. So if you don't pay them the way that you said you're going to pay them by the time you say you're going to pay them, they can go and foreclose, which means that they're saying, hey, I have a security interest. They haven't paid me. I'm going to force a sale of this property, get my money back, and the rest of the money goes to the owner. You can transfer your property. You can deal with your property as part of your estate plan even before you have paid off the mortgage. And so if this is new to you, if this is something that you also heard that you had to pay off your mortgage before you can leave it in your estate plan and you don't mind sharing, I would love to hear that to see if that was something that helped someone to see something differently that maybe they hadn't seen before. But if you're not on this call, I know I've talked to a lot of people, even within the past few weeks, where they were surprised to know they actually could create an estate plan, even though their property had a mortgage on it. And then I see here, this is actually the second part I was about to say. So this comment says, suppose the home is paid in full, yet the county holds property taxes, annual interest in it, or the home is established on ground rent land. So, um, I don't know exactly what specific situation you might be referencing, but what I will say is that if you don't pay your county property taxes or your local city property taxes, then the entity that you owe property taxes to, they can also foreclose on your property. Same way with a mortgage. It's a different process, but it's the same concept that they hold an interest that can be foreclosed upon if you do not pay that entity, whether it's the county or the city government, whatever entity that you are paying property taxes to. Here in the state of Georgia, we pay to the county and to the city, depending. Now, here in Bibb, we have a consolidated government, so we just pay to make it Bibb County. But in other places, they pay to the city and to the county. And if you don't pay those taxes, that municipality can foreclose on the property. They can sell it at a tax sale, and it could be different, one of two different ways that they can do that, but they have an interest in your property that can be foreclosed upon only to pay the debt. Once the debt is paid, the rest of the money from the sale is yours. So the person who owns the property, and it's sad to say you might have $150,000 property and you owe $5,000 of property taxes, your local government can go and do a tax sale, force your property to be sold, take the money out to pay their taxes and then whatever fees they have, but the rest of the money is yours. So that's another issue that people often encounter. Their property will get sold at a tax sale and you won't hear from them again. They don't realize that they're actually entitled to the excess funds from that tax sale. The extra money that was generated from the tax sale goes back to the owner of the property. Now, when it's heirs property, which means that a lot of family members own the same piece of property, sometimes it'd be hard to get that money back because that money is owed to so many people and the county doesn't know who they owe money to. So they just hold the money into an account and it's going to be up to the heirs to go and file something to say, hey, you're holding my money. I need you to pay my money. And this is how I know I'm entitled to it. So I just wanted to like kind of dispel some of those misconceptions. I encourage everybody, if you own property, that you pay those property taxes because the county, the city, they can foreclose on you. And we don't want that to happen. However, you still own that property. If you purchased it or you inherited that property, you own it. So again, back to the question of what happens to our property after we die. If you have a will or a trust in place, that is one major component of an estate plan. If you have a will in place or you have a trust in place, you've basically created a legal document that specifies when I die, I want my property to go to this person or these individuals. I want this particular person or these particular people to be in charge of carrying out my wishes. I want my property to be distributed in this particular manner. You might say, like you have a house, you might say, I want my house to go to one child and I want everything in my bank account to go to another child. Or you might say that I want my house to go to both of my children and I want it to be that when one of them dies, then the other one automatically inherits it. You can set those rules in place by having an estate plan. And that could be, as I mentioned, a will or a trust. Sometimes it can be done by a certain type of deed. If you've created a life estate deed or a transfer on death deed, or in some places they have what's called a ladybird deed, you can put certain deeds in place to make sure that after you die, your property goes to the person or the people that you want it to go to. But let's say that you didn't get around to creating an estate plan. You didn't get a will in place or you did not get a trust in place. What happens to your property after you die? Again, it does not just automatically go to the state. A lot of people think if you don't have a will or a trust, then their property goes to the state. And that is not true. I cannot emphasize that enough. There is a process called the law of intestate succession, which is the process through which your property passes to your heirs at law based on your state law. So who your heirs at law are is going to be different depending on what state you live in. But there is a process through state law that dictates what happens to your property after you die. Again, like I mentioned, that law is going to vary state to state. Here in the state of Georgia, when a person dies, they do not have a will, they do not have any kind of estate plan, or it could be that they have a will or a trust in place, but they didn't say what happens to this specific piece of property. So in that case, the laws of intestate succession or the laws of intestacy, those are going to come into play to say who are your heirs at law. Again, in the state of Georgia, what happens is if you die, you do not have a will, you do not have a trust. First, we're going to look to see where you married. We're going to next see, do you have children? If you are married and you have children, your property is going to be split between your children and your spouse, your spouse and your children. Your spouse gets at least 1/3, and your children are going to split the remaining 2/3. Now, if you only have a spouse and one child, spouse gets 50%, child gets 50%. If you have a spouse and two children, everybody gets 1/3. You have a spouse and 10 children, your spouse gets 1/3, your children share 2/3. Everybody is going to split this the same way, based on the calculations I just mentioned, based on the fractions I just mentioned. Everybody's going to get that. So if you have two houses, some land, you have a car, you have a bank account, all of those going to be chopped up in terms of ownership so that The spouse gets 1/3 of the house. The spouse gets 1/3 of the land. The spouse gets 1/3 of the bank account. The spouse gets 1/3 of the car. And the children gonna split that 2/3. And this could be that this family property is now owned by people who are not who are not blood relatives to the original owner, because if someone dies and their interest goes to their spouse and children, then that's going to put the property into partially into that spouse's estate. And then when the spouse dies, if we're gonna look at who their heirs are, and their heirs could be your children, or their heirs could be their brothers and sisters, or if they've gotten remarried, their heir could be their new spouse. And you could just see how over time the number of people could increase in owning this property. So back to the state of Georgia, you have a spouse, you have children. They're going to split your property. If you don't have children, then your spouse gets everything. And if you don't have a spouse or children, now we're going to be looking at your parents. Are your parents still living? If they're deceased, I can't remember if it goes to your grandchildren, I mean, your grandparents at that point, or if it goes from your parents to your brothers and sisters. But just either way, you can just see how things can just get very fractionated, very divided up into a lot of different people. So let's say it goes to your brothers and sisters. If any of your brothers and sisters are deceased, their part goes to their child or their children. And that the state is going to just keep looking. Well, I say the state, whoever's handling your estate, they are going to keep looking to find some heirs. It's very rarely that the property just automatically goes to the state. And when I say the state, I mean the state that you live in. Very rarely is that property going to automatically a sheet to the estate, as they call it, unless they just can't find the people who are your heirs. Nobody can locate your heirs. Nobody has come forward. Usually there's going to be somebody who inherits your property. The crazy thing is that a lot of times people are inheriting property and they don't even know it. So they don't know they got property taxes to pay. They don't know that they got grass to cut, that they got windows to keep maintained. They don't realize that. And so then the property just sits there time after time after time. Next thing you know, it's being sold at a tax sale or code enforcement stepping in, and that property is being lost. So that is what happens, what can happen with your property if you die without a will or a trust in place, without an estate plan in place. So I just wanted to give y'all that overview so that everybody can have an idea of what happens to property when someone dies without a plan. And then we're going to talk about the type of plans that you can put in place to prevent the issues that I talked about. Before I go to that next part, I'm going to talk a little bit about what happens when you have heirs property, like I just mentioned, this property that's been passed down from one generation or one person to the next generation in such a way that now you have multiple people owning this one piece of property. We're going to talk about some of the issues that could come up with that. Then I'm going to look at the comments and the questions, see if there's anybody who had a question I need to address, and then we'll go into some of the prevention things. So, heirs property. That's what happens when people die and they either don't have an estate plan in place, or they had a plan in place, but they left their property to a whole lot of people. So a lot of times you'll see someone had a will and they say, my house, I leave it to my 5 children. They basically have created heirs property. Even though they had a will, they left it to 5 different people. And then if one of those 5 people dies, then their interest goes to their heirs. And it just goes on and on and on until you have a lot of people owning one piece of property. In the state of Georgia and in many other states, the situation that you end up with is that no one person can sell the property. I actually had someone to talk to me today where they said that they had a grandparent or a great grandparent who owned a house. And over time, they're the only one that they can really trace who knows about the property and who owns an interest. But the problem is, this is like a great grandparent. So you have to see who were the great grandparents' heirs. Then you have to look at each of those heirs, see who their heirs were. And then you can determine who owns an interest in this property. You can't sell it just because you're the one paying the taxes and you're the only one that you know about. Other people will say, I can't buy this property from you because you don't have clear title. if you own farmland or agricultural land, it's going to be hard to lease the land. It's going to be hard to take advantage of USDA programs. It's going to be hard to, if you have trees on your land, it's going to be hard to sell the timber at a good price because you have so many people owning this one property that nobody who has a legitimate business is going to want to do business with you because you can't guarantee that you have clear ownership of the property. They don't want to get sued. They don't want to get in trouble. So they're not going to do business with you. And if you find somebody who will do business with you, more than likely, you don't need to be doing business with them. I always tell people if you got somebody who will buy your timber and you don't have clear title to your property, you usually need to run. There are some companies that will allow you to basically sign an I have a hard time with this word, indemnity clause, basic or contract basically saying, I'm going to sell my timber to you. And if somebody comes up and they want to fight you about the fact that I sold the timber, then they're going to have to deal with me. So I basically will bail you out if somebody comes forward and says that we did something wrong. And you can imagine that most people are not going to want to do that because it puts them at a lot of risk. And so if you find a company who's willing to let you sign that, you might be able to sell the timber, but in many cases the title is so messed up that nobody's even able to sign anything like that because they just don't know who might come out of the woodworks and say, I don't think you should have sold my timber and now I'm gonna sue you. A lot of issues come up when someone goes onto this family property and someone gets injured. And who do they sue? Are you going to be end up being the one that gets sued even though you have all these other people owning the property because you're the only person they can find? There's a lot of issues that come up with heirs property. You can't, like I said, you can't sell the property. If you need to get a loan to help you make improvements to the property, most lenders are not going to lend money to someone who owns heirs property. They want to know that they got all of the owners identified and that they want to deal with one or two people. They don't want to have to deal with 10 people because you got 10 people signing a contract and then one of those people decide that they're not going to follow through with it. You got to chase after your money after all these different people. Most lenders and legitimate companies don't want to deal with that. So those are some of the issues that come up with heirs property. And my goal is to help you all to prevent yourself from being in a situation where your property becomes heirs property, prevent your family from having to deal with heirs property issues down the line. But again, sometimes you getting this information after this property's been in your family for 3 or 4 generations. We can't go back and fix the past, but there are some things we can do to fix issues that have already been developed so that you can use your property the way you want to into the future. So I'm going to look now at the chat to see if I got any comments or questions that I can answer. Okay. I think I just brought up what Annie just said. I think I just talked through that where family members own siblings inherited a house and they're having a hard time selling the property. Um, it really probably will take at least 2 years or more to get clear titles to sell the property. And that's just kind of the harsh reality of it. These are some of the things that from a policy standpoint, I think that these kind of stories need to be heard more by the people who are passing our laws and creating legislation because there really is no shortcut way. You have to go through the process. It might be that you have to probate multiple estates or that you're going to have to locate all of these heirs. So you have you and your siblings inherit a property, and then some of the siblings have died, and now their children are part of this, and maybe even some more layers of children are part of this. You have to go through the process of either probating each estate of someone who's died or locating the heirs and having them to sign an affidavit, sign deeds over to you. But that 2 year time period may have come from the fact that even to try to clear title using affidavits and deeds, what we use is something called the title standards, which is the rules that we real estate lawyers look to see what's required to create clear title. The title standards say that if it's been less than 3 years, more than likely you're going to have to go through probate court. So that's where that 2-year period may have come from, that you're either going to have to go and probate all of these estates, which one estate is going to take no fewer than 6 months to probate. So you got to probate all of these estates, or they could be talking about the fact that if you want to deal with it outside of the probate process, you can't even start to do that until it's been more than 3 years. So that is something that really there is no shortcut. It might be 2 or 3 years to clear heirs property. In a lot of cases, it's even more than 3 or 4 years, just because one, people don't have all the money saved up to handle this all at once. They gotta come up with the money over time. And then also you have so many different groups of people that you have to deal with. Sometimes you have to try to get everybody to agree. And y'all know it's hard to get 2 people to agree. Try to get 20 people to agree on one thing. It can be really hard. So it's just a lot of steps that are required. And I always encourage my clients, let's have a long range view of this. Yes, you want to get it done today. That's probably not going to happen. But if we start on it now, maybe in 2 or 3 years, we can have it resolved. Another thing when it comes to a house or it comes to land, even if you can't sell it, which might be your goal, maybe you can start to lease it out. Because if everybody is in agreement about leasing it, or even if you have the only people who raise a fuss about it, that they all agree, maybe you can start leasing it out to someone just to bring in some income and allow the family to still benefit from the property. Or if it's land, you might be able to lease it out to a hunting club, or maybe you can sell the timber if you can get the timber company to agree to the indemnity contract that I talked about before. There's ways to still make some money, to still get some use out of the property in the interim. But I know a lot of times people are like, I just want to get this done ASAP because I'm tired of dealing with it. And unfortunately, that might just not be possible in a lot of situations. Someone asked, is there a statute of limitations on filing intestate succession or property was in a reverse mortgage? Um, there's a lot going on in that question about statute of limitations. So what I will say is that for the state of Georgia, there's no statute of limitations for by which you can probate an estate. Um, there are some timelines that could come into play, but they're not necessarily statutes of limitations. It's definitely a situation where you need to talk with a real estate lawyer who is also either an expert in probate or very familiar with probate process, because they can help you to come up with the best strategy so that you are in compliance with any potential statutes of limitations. Or there's even this thing called latches, which is not a specific time frame, but it's been too long. That's it's an equitable principle, and I'm using all these lawyer words, but it's something that may not be written in the laws, but it's based on what the courts determined to be fair. And sometimes, even if there's no specific time, like a 2-year statute of limitations or a 6-year statute of limitations, it could be it's been so long that it's just not fair to let you get away with this anymore. Or it's just been too long that now it's too late for you to bring this court case, because if you had brought it sooner, then this would have been in place. But since you waited, now we got this in place. Basically, what I'm saying is there's a lot that could be going on behind the scenes, and having an attorney look at your specific situation is going to be needed, because they got to look at all the pieces and help you to figure out what's the best path to get to your ultimate goal. And we have here where Dorothy said, what happens if the child gives the wife everything? So when it comes to probate or inheritance, if family can agree on a good course of action and they can decide what do they want to do, it might be that the surviving spouse lives in the home and they want to keep the home, and the children agree to deed over their interest in the home to that person. That could be one thing, or even that could be handled through the probate process. You might file a probate case, and then the children disclaim their interest to the surviving spouse. So that is an option as well. There's often a way to get to whatever goal you want to get to. if everybody's agreeing and on the same page. The reason why we have the laws we have is because a lot of times people don't agree. And so the law is there to help us to figure out what's going to be the best path to resolve this dispute so that people don't resort to shooting each other or trying to fight it out in a duel, because that's how people used to resolve complaints with each other. They just say, all right, who are the last man or the last woman standing is going to win this battle. And the law of the state is like, we don't really want people doing that anymore. So we have laws. But if y'all can figure it out on your own and everybody's on the same page, we'll let you do that. There's a way that the law can support you coming to a resolution. And so what I would say is I encourage everybody, if there's a way that you can work it out with your family member and y'all figure out the best path moving forward, get you a great attorney who can help you to put your plans in a legal format, then you're good to go. More than likely, the judge is going to be like, if y'all good, I'm good. And they happy. If they can sign off on something and keep it moving, they are happy. If they don't have to have a whole court hearing and evidence. I don't lawyers and judges don't, well, some lawyers just like to fight. But I think most of the time the judges are happy to just sign off on something if y'all can agree on it. I hope that answers your question. If any of these things that I covered it did not get answered, put it in the chat again. Okay, I'm glad that answered your question. All right. So we talked about what happens to your property after you die. We talked about what happens when you don't have a trust or a will in play, when you don't have any kind of legal estate plan, legally an estate plan that the law is going to honor. When you don't have that in place, an estate plan that follows legal guidelines. We talked about what happens to your property. It does not automatically go to the state. Y'all remember that? And if you have a mortgage on your property, it does not automatically go back to the bank. It's really important that you move quickly, though, if there is a mortgage, because a lot of times what ends up happening, it look like it's going to automatically go to the bank, because if somebody has a mortgage on their property and you don't pay that mortgage within just 2 or 3 months, then it can be foreclosed on. And Georgia's foreclosure process, like I said, that's not my area of forte, but I encounter it a few times here and there. They don't play, and they're not going to give you a whole lot of notice. If they want to foreclose because you didn't pay this mortgage, there are certain rules in place in your security deed for your mortgage. And if you don't follow those rules, then they have a process by which they can foreclose. Basically, they're going to send you a certified letter and be like, we're going to foreclose on this property. And if you don't respond in a certain time, next thing you know, that property is going up on the auction block. So this is a real issue when somebody dies, because sometimes they're dying and nobody else lives at the house. Somebody might go check the mail every now and then, but for the most part, the house is just empty. So there's nobody there to get the mail to see that a foreclosure letter was sent, or that there was a letter tacked on the window, I mean on the door, because there was a storm and it blew the letter away and nobody saw it. So a lot of times people are having their properties foreclosed on before their family is able to do anything about it. So if somebody dies and they own real estate, especially if they have a mortgage, you need to be moving very quickly. And I mean like within 30 days, because you want to make sure you don't miss any letters from the mortgage lender saying, hey, if you don't pay this, we're going to foreclose. And you also want to make sure that you are paying the mortgage. And you got to figure out how much that mortgage actually is, because sometimes, like especially if somebody is sick before they die, they may have already missed a mortgage payment before they died, and so you already behind. So it's very important to move quickly, communicate with the mortgage lender as much as they'll allow you to, and get an attorney to help you to go ahead and probate that estate, because you got to move really quickly. And that mortgage lender is usually not going to talk to you if you are not on the title or you are not the executor or the administrator of the estate. Someone says, is it possible or legal for an heir to sell their interest in heirs' property to someone outside the family? If so, what can be done to prevent this from happening? That is a really great question. So yes, it is possible for someone to, and it's legal for someone, an individual heir, to sell their interest in the property, because it's their interest. They own it. You have this whole property, and what happens with heirs' property is everybody owns their interest. It's called a an undivided fractionated interest. So that means that the Thaddeus is on here and he like to tear dollars up. I don't like tearing up dollars, so I'm gonna tear up this paper right here. You got this paper, this is your land right here. If it's a 50% interest, you split it in half. This is like everybody owning their interest in the property. This is when you actually divided it. But this is not how heirs property goes. So let's pretend like this is a heirs property, a whole property again. What an undivided interest looks like is it's just folded. So you own your part, but it's still connected. You see that how it's folded. This is one person's part and this is the other person's part. But it's undivided. When it was like this, one piece of paper split, that's divided. But that's not most heirs property. It's gonna be one piece of paper and it's everybody owns their interest. So you might be person A over here and this is person B over here. Person B might decide, I want to sell my part to person Z. And they can do that. They can sell their part because it's their interest, but it's still going to be connected to the other owners. So what happens with heirs property is that you have all these people inheriting undivided fractionated interest in the property. Any of them have the right to sell their interest to anyone they want to. They can transfer it to anyone that they want to. And then another issue that I forgot to mention earlier is that somebody might decide I don't like owning my property with these people like this. So I'm going to ask the court, can we split this property up? Can we partition it? Or can we split it up and then everybody get their money? They have a legal right to ask the court to divide the property up or to sell the property so that the money can be split. That's called a partition. They have a legal right to ask the court for a partition. And so the way that we prevent people from doing this is really, again, coming together and agreeing. You can create a new framework where instead of it being an undivided, instead of it being the property owned by everybody, being in everybody's names individually, we might decide to transfer ownership to an LLC or to a trust. I prefer LLC when it comes to heirs property. We can have everybody transfer their interest to an LLC or a trust, and we create an agreement that says instead of you selling it to somebody outside the family, you have to first offer to sell it to somebody inside the family. And if you still don't want to do that, then only after certain conditions have been met, would you be able to sell it to someone outside the family or transfer it to someone outside the family. So the only way to really prevent someone from being able to transfer their interest to someone else is to create a new ownership structure. Because when it's that property that's been inherited by different people, everybody's inheriting their different interests. The law that we're looking at is this. Well, let me not go into all these lawyerly things, but there's certain laws that say what your rights are, and so you have the right to transfer your interest. You have the right to sell your interest. You have the right to ask the court to divide your interest from the other owners. But doing so, there's nothing to prevent you from doing that unless you create a new structure where you create your own rules. Like I said, an LLC or trust. You can also create what's called a tenancy in common agreement where the people who co-own this property, they agree that, hey, at least for the rest of our lives, none of us are going to sell to someone outside the family unless certain conditions come into play. Or you might decide to say, hey, no one can sell. We all agree to this. But you really have to think about what's going to be a practical way of existing as well. Because I tell people all the time that just because you think it's a good idea to say you can never sell it, you can never do this, you can never do that, the reality of it is that you got to see what's going to make sense. Because you might say, hey, you can never sell your interest, but I'm not buying it from you either. So then you basically co-owning property with someone who is there under knife point. It's like you forcing them to be part of this property ownership. And that doesn't usually end well. Usually the person who doesn't want to be a part of it, after a while, they're going to show they don't want to be a part of it. And they're going to make it hard for you. And then maybe even result in the whole property being lost from everybody because you got this person who is not working with everybody else. So it's just those kind of things that you really would need to think through. But to answer that question, if Virginia asks, about, is it possible or legal for an individual heir to sell their interest in heirs property? Yes, they can sell it to anybody, somebody in the family, outside the family. And the only way to prevent that from happening is to create a new entity to own the property and create rules for how y'all gonna jointly own that property through an LLC, tenancy in common agreement, trust agreement, things of that nature. So we talked about heirs property. We talked about what happens to your property when you die without a plan in place. I want to talk about having a plan, creating a plan, and then I want to talk about probate. The big P. Some people scared of it. I'm not scared of probate. I don't want y'all to be scared either if you live in Georgia. Now, if you live in somewhere else like California or Florida, it might be a little more crazy, but here in Georgia, it's not too bad. So let's talk about estate planning. I say everybody needs some level of estate planning. I don't care if you own a multi-million-dollar property or if you don't own any real estate and it's just you. And this kind of gets to one of the questions that was asked earlier about, can I create a trust even if I don't have the assets that I would want to ultimately put into the trust? So everybody needs an estate plan. And the question is, what level of estate planning does an individual need? Some people are going to need a more comprehensive, extensive estate plan than others. If you own real estate, you own, especially like if you own a farm or you own a business, you own multiple assets, you're going to need a more extensive estate plan. If you're someone who is going to continue adding to your portfolio, acquiring additional assets, then your estate planning is going to be different from someone who may be a senior, they're elderly and they're thinking, the house that I have and the bank accounts I have, my vehicle, that's pretty much all I'm going to have. I don't plan on buying any new property. I don't plan on adding to my portfolio. That type of estate plan is going to be very different. Also looking at someone who is just getting started in life, they're about to go to college. If they're over 18, they do need an estate plan, but it just may not be as comprehensive as one for someone who is still acquiring assets and has a lot of different assets in their portfolio. So with that being said, let's talk about the types of estate planning tools that we have at our disposal. First thing is, what happens if you get sick, you get in an accident, you're injured, you're not able to make decisions for yourself? This could be someone who is 18 years old or someone who is 88 years old. We all need to have legal documentation in place to say, who can make medical decisions for me if I'm not able to communicate those to my doctor? Who can make financial decisions for me if I'm not able to handle my own bank accounts? I can't make it to the bank. I can't, even if I lose the capacity to make certain legal decisions or financial decisions, who's going to be in charge to make those for me? I don't care if you're 18 or if you are 88. You need to have legal documentation in place to provide for those different decisions. That's going to be a financial power of attorney. It's going to be an advanced directive for healthcare. Some places will call it a healthcare power of attorney, or they'll call it what's the other word? Power of attorney, or I cannot remember the other phrase that we use. Oh, living will. Yes, I'm glad I said that. A living will. Living will deals with what happens to you medical wise. Here in Georgia, we combine the healthcare power of attorney and the living will into the same document. We call it an advanced directive for healthcare. It allows you to say who will make medical decisions for me if I can't make them for myself. And it also allows you to put certain medical decisions in writing so that you can say, this is what I want done in certain circumstances. So that is going to be your healthcare advanced directive or healthcare power of attorney, your living will. Not to be confused with a will, living will. This is basically a document that says, what happens if I'm terminally ill or I'm permanently unconscious? What do I want to happen with my life? What decisions do I want made? What medical decisions do I want made? That's what your living will or your healthcare directive allows you to do. Financial power of attorney allows you to name someone to make financial decisions for you, but it also allows you to say what powers you are going to give that person, what powers they do not have. And the good thing about a financial power of attorney is that it allows your family to avoid having to go through probate court if you were sick or permanently unconscious and you can't make decisions for yourself, or even if you're not even at that stage, but you might be losing some mental capacity due to dementia or any kind of medical issue. You get to have somebody in place to handle your money, to handle your business, your real estate. If you don't have that in place and you lose that capacity, your family may have to go to probate court and get a conservator appointed. And that's a lot of time, money, work. It's just a lot that goes into getting a conservator appointed. And we want to avoid that if we can by having a financial power of attorney in place. Because one thing about a conservatorship is that that's something that happens outside of your control. That's something that somebody else is going to be seeking on your behalf. But if you have a financial power of attorney in place, you get to be the one that makes those decisions for yourself. And you get to put the people in place that you want to be put in place to make those decisions for you. And that's what most of us would want, to be able to make the decision for ourselves instead of having to have somebody else make that decision for us. So those are the things that everybody is going to need financially and medically. They're going to need a financial power of attorney, healthcare directive. Talking about what happens after we die. How do we put a plan in place so that we have those decisions made? That can be done through a will, or it can be done through a trust. And it also, like I mentioned before, it could be a result of, you could also use different deeds to help put those decisions in place as well, like a transfer on death deed, a ladybird deed, a life estate deed. Those are also things that are done as part of your estate planning. A will is a document that allows you to first state who's going to be in charge of your final affairs. That's your executor, the person who has the legal authority to handle your final affairs, make sure that your property is distributed the way that you want it to be distributed. Their job is also to pay your final expenses, not out of their own money, but they will get the legal authority to write a check from the funds that you left behind so that you can pay off debts like your funeral bill, medical bills, any kind of, there's certain financial things that would have to be paid. Sometimes if you had creditors, certain creditors would have to be paid off. There's a whole process on who gets paid first. So it's very important you talk to an attorney so they can tell you, pay this person, then this person, and this person. And if this person's at the bottom of the list and the money is gone, they just don't get their money. Some of the people that are at the front of the list are surviving spouse, surviving minor children, the person who's your executor or your administrator. Those people come first. The funeral home comes first. The hospital is going to come after those folks. So there's a priority on how certain expenses are to be paid. And it's very important that you pay it in that right order. So you have the executor, who is the person you've named in your will to handle your final affairs. In your will, you get to state who gets what, how they get it. If you have children who are not over the age of 18, or they're still too young where you think that they don't need to be getting whatever you're going to leave them, you can state in your will that they get a certain amount at different ages. You get to say if you want to leave your property to your church or your favorite nonprofit. You get to leave your assets in the way you want them to be left. You also get to say, put other wishes in place. Do you want your executor to have to get a bond, which is like an insurance policy where they have to basically get insurance to, just in case they decide they're going to run off with everything? They have a bond in place so that at least your heirs will be compensated if they did decide to run off with everything. You also can say, will my executor have to file reports with the court? Or are they going to be relieved from filing reports? All of those are things that you can address in your will. The thing that's very important to know about a will that a lot of people get wrong is that a will does not become effective until it is probated. So the person will die, and then the person who's named as the executor over their will, they can take the will to probate court. They have to file a special document called a petition, and they can get that will probated. But until that will goes through probate court, the executor doesn't have the power that's listed in the will, and the property's not, they don't have the legal authority to transfer that property as is listed in the will. The will has to go through probate court. A trust is another document that people use for estate planning, and it's designed so that you don't have to go through probate court. Basically, what you do is put all your instructions in place for your trust, and you transfer the ownership of your property to the trust. So that now, instead of you owning the property in your personal name, it's going to be owned in your trust. And then your trust can transfer through your trust, your trustee, who's the person over your trust, they can transfer the property as is indicated in your trust. So that's a way that you avoid probate court. Transfer death deeds, life estate deeds, those are tools we can use to avoid probate court. But if you create a will as the foundation of your estate plan, that has to go through probate court. And that's something that's very important for people to note. So I just wanted to give that guidance. One more thing I'll say, if you don't have a will or a trust, then your family can still administer your estate through probate court. And they basically will administer your intestate estate. They would request letters of administration, which will give the person asking to be over your estate the power to be the administrator over your estate. And from there, they can basically resolve your estate just like your executor would, except you didn't get to say who you wanted to be in charge, and you didn't get to say who you wanted to receive from your estate and how you want them to receive it. All of that is going to be determined by state law. But there is still a legal process available if someone dies without a will or without a trust to make sure their property gets from the deceased person's name to the living family members. In the state of Georgia, probate is not something to be afraid of. We can plan to get around it if that makes sense for you. But if your family has to go through probate court, it's not a scary process. It's not super expensive, and it's not super long and drawn out. It's going to take some time. It's going to take some money, but it's not an impossible barrier. And so I encourage people, don't be afraid of probate court. In fact, I have a little video that I did where I talk about don't be afraid of probate court, because it is something that a lot of people are afraid of, but it's just because they've heard so many things that's just not true. So if you get scared, talk to an attorney, a probate attorney who can walk you through the process and handle a lot of that process for you as well. So that's what my firm does. I'm gonna go ahead and start bringing this thing to a close because we're just over an hour for this presentation. So I want to go ahead and start wrapping it up and let y'all know that, hey, if you want help with putting your estate plan in place, or if you have a loved one who's died and you need help transferring that property to the living heirs or beneficiaries of the will, that's exactly what my firm does. As long as you're in the state of Georgia or the property's in the state of Georgia, my firm can help with that. And if it's something that we can help you with, I will put the link to scheduling a consultation with me in the chat. And we also are going to send a follow-up email after this webinar where you'll get information on how to schedule a consultation with us. But in the meantime, I'm going to take a few moments if someone has questions. This is officially the end of the webinar, but if you have any questions or comments or concerns that you want to raise, we can talk about those now for the next few minutes. But otherwise, if you got everything you need tonight, then I thank you so much for attending, and we'll be back here again next month on the third Sunday of July. So y'all take care. And like I said, I'll hang around a little bit if anybody had any questions that I can answer for you. Thank you for attending. Awesome. I'm glad that this was helpful. And again, if you have any questions, you can unmute yourself and ask the question, or you can put it in the chat and I'll take a few moments to answer. All right. Doesn't look like anybody has any questions. So thank you again for attending, and I'll be in touch with y'all by email to let you know how to get in touch with us if you want to schedule a consultation. Someone says, are we open for mediation to heirs of heirs property? We don't really do mediation formally, but a lot of times we end up doing some form of it when we're working with our clients. The Federation of Southern Cooperatives has a mediation program to help people mediate heirs property. But there's also some other mediators that might do it as well. So reach out to us and we can maybe connect you with someone. There's a really great heirs property mediator in Arkansas. She's only in Arkansas, but I wish she was in other places because we need people like that. But currently, we don't offer that service. But something I would love to offer in the future. So stay tuned, but it's going to be a little bit farther out in the future. But thanks for that question. So,
Veronica, I
yes.
apologize. I have a quick question.
Hmm.
Um, I, you're going to be helping me with my family with the heirs property. And so I missed the first half. I apologize. I'm actually just coming back from the farm. But, anyways, I wanted to know if the family cannot come to a resolution, like come to an agreement, everyone. Because, like, the problem with these heirs properties in my family is probably about 30 plus of us. Um, what typically happens? Is that what you're saying? They go to mediation, or we have to go to like a judge, or
Yeah, so mediation can be an option. And a lot of times we got to get to the root of like what the issue is that's causing
Mhm.
people to be at odds with each other. Sometimes the issue could be some people just they misunderstood what the law was. And once we can help them
Mhm.
understand what the law really is about a situation, that might help clear it up. Sometimes it's an
Okay.
issue that is outside of the land that people just got some other personal things they need to resolve before they're ready to work with their family members about the land. And sometimes that'll come out and we might be able to help the family to connect with resources to help them resolve the real issue that's stopping the hindrance. So a lot of it is really getting clear on where the issue lies. Sometimes
Hmm.
people think like what we talked about earlier. It was something that was discussed earlier. I can't remember now, but there's certain misconceptions that people have, and they're arguing over something that's just not even real. And so sometimes it can be
Right.
uncovering like what actually is true versus what people heard was true, and helping
Right.
people to figure out like how to come to a solution from there. So I don't know if that helps all the way, but really it's just like any other relationship issue when it comes to dealing with heirs property. Sometimes you got to get just make sure everybody's really clear on where the issue lies before you can start fixing things.
And quick question, because that sounds like my family. What do you suggest people to do before meeting with the attorney? Like I think my cousins and we met already to prepare for the meeting consultation with you. I have to speak to my aunts to kind of see, but I've already heard some resistance kind of through the grapevine. So I'm trying to resolve that before we even come to the table. So everyone is playing nice when we meet with you and be on their best behavior.
Yeah,
Um,
I know one thing is a lot of times when the younger folks start trying to do stuff, then the older folks might have some resistance to it. One, they might think, I changed your diaper. What are you talking about? That I need to do something. And sometimes they think that the younger people are trying to take over. So I think that that's where the one-on-one conversations can help, where it's just like even asking. One thing I always tell people is, hey, ask them like what do they want to see? Because
uh-huh.
sometimes you might be more aligned than you think, but everybody assumes that the other person is doing something, and it's really
Mhm.
a matter of, really what I would want. I just want to make sure that we always keep the family home, and or it might be I don't want anybody to kick me off the property or to say I can't visit it. It's sometimes really understanding what the resistance is, but sometimes the way you find out what the resistance is by finding out what they actually want, and then see
Yeah.
if there's a way that we can all get what we want. Sometimes it's telling them, hey, we're not making any decisions right now. We're just here to get information. We're here to get guidance. So why don't we all come with an open mind and a heart and see what we can learn that can help us? Because I found that when I talk to people sometimes it softens things because they're like, oh, I thought that you were gonna be like some crazy lawyer out here trying to, have us fighting with each other. And then I see that you're actually here to try to help us to find a solution that everybody can, if they don't agree 100% on, at least they can partially agree on it. Sometimes that helps too, if people just actually see what is actually happening versus what they have in their head about what might happen.
Yeah, I agree. Thank you so much for that.
You're welcome, and looking forward to talking to y'all.
Yeah. Thank you.
All right. Anybody else have a question? Well, if there is nothing else from anybody, then I'm gonna go ahead and wrap up this webinar. But I thank y'all again for tuning in, and we'll be here next month. Um, I'm gonna be sending out some emails about following up from this. And if you have a question or something you want me to dig more into in the future, either webinar or YouTube video, because I do YouTube videos as well, let me know. Just respond to the email and let me know, and we'll make sure that we cover it in the future. Y'all take care and everyone have a blessed week as well. And so.